in listen-only mode.
Welcome and thank you for attending this session of Lexbe's eDiscovery webinar series, Best Practices for Litigation Timelining, presented by Lexbe Principal Gene Albert. Our eDiscovery webinar series takes place once a month and we cover a wide variety of relevant issues related to litigation technology and legal document management. Today's webinar should last 20 to 30 minutes and we'll have a URL to access a recorded version of the presentation available for anyone who registered later this week. To give you a brief overview of our focus at Lexbe, we develop technology that helps legal professionals meet discovery deadlines. We offer fast, high-capacity document conversion and processing services, as well as our full-featured review platform, Lexbe eDiscovery platform, which includes self-serve processing functionality and robust case management features, including timelines. If during our webinar there are any questions that you have or any technical issues being experienced, please email them to webinars@lexbe.com. Before I turn things over, let me tell you a bit about Gene. As mentioned, Gene is a principal and co-founder at Lexbe and has a wealth of experience consulting on large-scale e-discovery matters. He's also an experienced attorney who's worked in in-house counsel as well as in private practice. Gene has also led ventures in medical services and other software and web-based businesses. With that, here's Gene with Best Practices Litigation Timelining.
Thanks, Stu, and welcome everybody. This is a really important and practical subject that I like talking about. I think timelining is really important and is a key skill for us in handling litigation. What we'll cover today is going over why timelining is more important than ever, how this relates to early case analysis, what that means, why timelining is often haphazardly done, what good timelining software should do for you, specific uses, some examples using our software, and conclusion. Why is timelining more important than ever? Well, one of the reasons is that there's more data than ever. So this graphic shows how the amount and type of data just gets larger and larger and larger. And that does not appear to be stopping anytime soon in our lifetimes. The more there is to go through. This is generally all discoverable. And at the end of the day, there tends to be a fairly limited number of documents that are really key evidence in a litigation and is really case determinate that but finding that evidence is getting harder and harder because it's just mixed in with so much other stuff, so much other junk. So why is it more important than ever? Well, there's more data captured. There's drafts of documents, text, email strings, and with being more document evidence, there's more recording of contemporary thoughts and impressions than ever before. In the past, when we did not have all of the electronic age that we have now, there was a lot of important things that really didn't get captured, didn't make it into letters, didn't make it into things enough. That's increasingly becoming less the case. So usually if one looks hard enough, there's some indication of what people did and why on almost any issue in modern life, and that becomes a subject of litigation. Another reason why timelining is more important is that attorneys are less involved in documents early in the case. In the past, maybe the distant past, the attorneys were really involved all through the case. Now, because of cost consideration, junior attorneys, outside reviewers, contract reviewers, technology is used to do initial review and production because there are just too many documents, two at a time. And now productions can be completed and out the door without the attorneys really looking at key documents in detail. so they get a less appreciation for what's going on in the case early on. Those key documents are in there somewhere, but they're harder to find among everything else. So say there's a pony in there somewhere. Another thing that's changing, in my opinion, is that in the past there was a lot, or in the present now, attorneys could get away and would sort of learn a case as they go. So in the many months of discovery and the initial parts of the litigation, even if the attorneys were not up on the case immediately, they would sort of pick it up as they went along. And that was probably never best, but it was certainly okay, and you would be educated through the process. That's more costly than ever, I think, if that was ever a good idea. But it's costly now because you don't pick up the documents in the normal course of document review, and decisions have to be made on case evaluation and how depositions are done, where if you don't know how the true case facts, that can be pretty costly. What are the advantages of timelining? Timelining obviously doesn't happen automatically. It does require time and input. What do you get back out of that? Well, and doing it early. Well, one is that you can find new documents, data sources, and custodians. It's can be a problem to miss those things early in the case and pick them up later, or if never. There are obligations to find custodians and data sources, and you certainly want to know about all the key documents. And by timelining out and identifying key documents early in the case, this will lead to other ones naturally through the course of doing that, and you can find these other data sources and custodians earlier. Custodians being the people that have evidence under their control. So that could be certainly the litigants in the case, people that receive subpoenas, but also outside, other individuals, IT people that have control over shared drives, that sort of thing. Another advantage of timelining early in the case is you're able to coordinate witnesses with the evidence, and that if you really know your facts before you put your witness on into a deposition, it's a lot easier to have that be a good deposition. Doing it early in the case allows you to tie the actions, elements, and jury instructions to the evidence. So you can start getting a feeling early in the case that do the facts tie with the documentary evidence that you have in the case so far. What further documents do you need? What needs to be developed in depositions or with further discovery? And you want to know that as early as possible, because it's easier to run out of time now if there's so much more being done in the discovery period. And this can relate to the case facts as you determine them from client interviews and also intended jury instructions. Another advantage is to assist in building a coordinated case story of what you're trying to do with the litigation for the trier of fact. And this includes both your legal case, your cause of action, the legal elements, but also story facts, the facts that you need to tell a coordinated and interesting story to the trier of fact of what happened. That can sometimes be a little bit different than the legal case facts, but both are important. What are the dangers of bad or no timelining? I don't think, I think there's any attorneys that don't do some timelining at some point, even if it's later in the case, even if it's walking to the courtroom. That would be rare. That wouldn't be done in a commercial case, of course. So we're doing it sometime. It's a question of what happens if you do it, if it's later, it wasn't done very well. Well, one is that your witness testifies inconsistently with the evidence. If you don't really know all the evidence, if you haven't timelined it, witnesses tend to remember, they don't remember everything that's been stored digitally, and that's for a number of benign reasons. One of them is that we all have selective and favorable memories of our past actions, what we've done, because of that, we need to really look at the digital evidence and see how these facts play out, so the witness can remember better and integrate in what is digital evidence with what their testimony is going to be. A failure to do that means that your witnesses in depositions will say things and they can be compromised on cross-examination because of that and made to look bad. A second danger of no timelining, and this is really the flip of the first, is failure to take advantage of opposing witnesses. If opposing witnesses come in and testify in ways that are inconsistent with the documentary evidence, you want to be able to expose that, or at least tie them down and expose them later. So the one of the purposes of deposition is to tie down the witness's testimony so they can't later fabricate or retell. So you really need to know what the documentary evidence is saying to be able to go in and do a good job of that. A third danger of doing bad or no timelining is you lose the opportunities. Part of that to properly value your case early. And one danger of litigation and frustration for clients is the and everyone is sort of leaking bad facts over time, that we go into a litigation early and have an optimistic view of our view of the dispute, and we don't really look at the bad facts early, and that because of that we have an optimistic valuation, and as these bad facts sort of leak out over time, then we change our value of the case, and we may have lost an opportunity early in the case to settle it. What in hindsight would have seemed a good number, but weren't able to get to that because we hadn't really integrated the bad facts, and timelining is the best way to do that. What is the relationship between timelining and the term early case assessment? Early case assessment, sometimes early case analysis, is a term that's been used a long time, but it's been used a couple different ways. A long-standing use of it is the way I'm using it in this webinar, and that's to assess your facts and witnesses, timelining chronologies, identifying key participants and IDing documents, interviewing, witness interviews, timelining. There's another more recent usage of it that has to do with the quantitative analysis of incoming electronic stored information, and being able to use the computer to pull out data about that, such as gaps of emails and collections and the types you have, and statistical distributions of emails and other case documents by time custodian. These are both valuable things to do, necessary or a good idea in many cases, but they're really different uses, just the same term. Our platform, Lexbe eDiscovery platform, does both, and the quantitative analysis is part of that. We'll discuss that in another webinar in the future, and then this one will focus on the timelining element of it, or aspect of it. Why is timelining often haphazard? If this is such a good idea, why don't we do this, all the time, every case? Well, there's a number of reasons. One is that, but I don't have it on here, but certainly some cases are just too small to really justify it, and it's not important, or it can be done in one's head. Once you get into a bigger, more complex commercial case, why isn't it done? Well, one is the attorneys are not involved in early document reviews, so they're sometimes out of the loop on this and the early stages of it, and other people are doing this, so they don't have the opportunity to go in there and apply legal expertise to timelining. Another reason is that timelines are often delegated to somebody junior, so they're left to junior associates or paralegals. And while certainly delegation is important and beneficial for the client, it's good for training. It can lead to the senior attorneys not really being involved in the key facts, so their timelining doesn't get done optimally. Third reason, and I think it's probably one of the biggest reasons, is that they're done with inadequate tools. So timeline is often done in Word or WordPerfect, or even on a legal pad. This makes it not dynamic and really hard to update. There's limited searching, and it doesn't dynamically update with new facts. It has limited functionality and isn't linked to the documents, and that's really a key shortcoming. If you can't get to the document quickly, then you get into a loop of looking at something and saying, well, this is out of date, update it, we'll meet next week, or I don't believe this fact, does it really say that? Let's go get the document, we'll meet next week and look at the document. And it ends up being just delayed so much that it ends up not being very useful or functional because it's just too hard and not immediate. So this leads to kind of always out-of-date timelines of limited usage usability. So how do we do this better? Well, specialty software for it is the best way to do this. What should good timelining software do or be? One is it should be easy to use. It should be software-based and pretty intuitive. It should be shared and accessible. And by this I mean it needs to be on a platform that many people can get on, the litigation team can see and use and update. It can be of limited value if this has to always go through one gatekeeper or person who has to keep it up to date. That makes it less usable, and you can't get to it easily. And if you can't do that, you just don't use it and you don't do it. It should be online and secure. Online because that means that you can access it. People on the team can access it from anywhere, anytime, from home, on the road. When you have new ideas, that's really critical to being able to think about a case and have your developing appraisal of it. And then, if it is online, of course, it needs to be fully encrypted and secure, as is ours. It needs to be linked to the files and evidence. I think timelines that don't give you an immediate link back into the original documents, your notes, the coding on the documents can be pretty limited. So good timelining software, that should all be a click away. And then at last, it should allow issue coding, filtering, sorting. Once you put these timelines out, you should be able to slice and dice them and look by custodians, case participants, issue, date, materiality, etc., for the various things that you want to do with the timelines. Uses for them. One of them is, and I talked about this previously, witness prep and cross. It's a great way to get your witnesses ready, to take the documents that they're involved in, timeline out the facts out of the documents, and then use that to prepare your witnesses. And you can develop these timelines from what your witnesses say, and it helps you develop what you want to develop in the timeline that isn't fully explained by the documents that you want to have oral testimony on. And it makes you better prepared also to cross and discredit, or at least tie down, opposition testimony. Next use is transcript analysis. Timelines can be used as a structured fact extraction of depositions and hearing transcripts that's much more functional than a depo summary. One problem with a depo summary is that it's common to have an issue that might be addressed several times to a deponent at various parts in the deposition, maybe even in different depositions. Questions can be asked different ways. You can come back to them, and if you're in a summary and that's on page 17, 97 and 207, it's very difficult to bring those together, and you're really left with going back to the index and trying to jump back to it. Very cumbersome. By structuring facts out of the transcript and making them into facts, then you can have them by date and by witness, and have them all grouped together, and by issue, so you can see together what the witness might have said on the same or similar issues in different parts of the depo. You can also relate key transcript facts to other depots, and also to the supporting exhibits and evidence, and you can easily see, once these are set up, what the witness says and as a fact, and how that relates back into facts as might be indicated on other documentary evidence, other transcripts, other exhibits. Case evaluation, settlement negotiations, by having the key facts set out and tied into original documents, your notes and your coding makes it much easier to both evaluate your case and then also in settlement negotiations to bring up examples that support your case and counter whatever is being brought up by opposition. Another use of timelining is for client meetings. Timelines really help clients during the progression of a case to see how strong or weak a legal case is, and to help clients maintain an accurate ongoing case valuation. And it helps, and on that point, because of the favorable memory that we have and that we don't see what the other testimony is, it's easy for clients to have an overly optimistic view of their case sometimes. And by seeing examples of counter evidence and being able to see what was really said or what was in emails or in their emails or others, and having that in an integrated basis helps clients get a better view of where they should be on valuing the case for settlement purposes. And it also sees how witnesses, or helps witnesses see how their testimony fits into the bigger picture. They tend to look at their own wet evidence or their own testimony in isolation and not fully appreciate the bigger picture. And a timeline is a good way of doing that, and is sort of an easier way than asking them to read half a dozen 100-page, 700-page deposition transcripts. Motion practice. Motion practices can happen pretty quickly, and there isn't a lot of time to respond. And it's important to be able to find key evidence points that help support your case. And we need to be able to look at facts and supporting documents by whether they're material, whether they're opposed, whether there's contrary evidence, and be able to pull out those pieces of evidence pretty quickly, be them transcripts or portions of transcripts or exhibits or other supporting documents, to attach them to motions for summary judgment, opposition responses, etc. Similar issue in trial. There'll be motions right at the beginning of trial and the end of trial. You want to keep the timelines up to date so you're able to pull the evidence out and integrate the evidence that was brought in for trial. Also during testimony for a fast and effective cross, it's really helpful to have timelines built up and dynamic so you can bring in new evidence in the courtroom and then see what other facts you have and be able to get to it quickly to pull it out. For there's not much time between the close of often between the close of a witness's testimony and the time to go on and cross. The other thing these timelines can do is they can serve as the basis for a timeline trial graphics to help make the important points very clear to juries and judges. Next, we're going to go into some examples. This is out of our software, Lexbe Discovery platform that's online. The first thing here is setting up case participants. So this is helpful in taking all of the companies and witnesses and deponents and parties and everybody who's factually, organizations and individuals who are factually related to the case, and showing what who their relationship is and some information about them. So that's kind of the who's on first aspect of it. That's a very helpful thing to do. And it's helpful to do it in an integrated environment so that these can be tied into facts rather than something that's just independent. Next is issue creation. And here, and this go in and create issues and describe them that are important for facts. So these could be, there are a number of different ways you can do these. These could be the cause of action elements, anticipated jury instructions, story facts, And this would be for claims and defenses and for both your own and your opponent's actions. Then facts can be created and tied into the document. So here a fact is on the left, and then the document link is on the right. And these could be pulled out of documents, out of transcripts. One document or transcript could have many different facts. A fact could be linked to multiple pieces of evidence, multiple transcripts or documents. And then once the date has been included, this you can show how these facts relate to each other and the time that they occurred. Then they should link back into the documents here. So here from a timeline up on the upper part of that, you would click on the document, and then that would open the document in the document viewer. On the left of the document viewer, which is on the lower left, you'd see the PDF of the document. And then on the right, this is the facts tab. So the facts can be accessed both within the document viewer on a document-by-document basis, and also they are integrated back into the overall timeline by issue. And each document can have many different facts in it. Next is assigning documents to deponents. So in getting ready for that and getting your facts and documents ready for a deposition, then you can go in and code document to the document level. Also look at all the documents that are related to an upcoming deposition, and then from there start to create facts from that. Now we're looking at a transcript, and here the transcript can be highlighted and facts created. So a deposition or other transcript might have hundreds or more different facts that were pulled out of it, and these would be identified, pulled out, and then they would automatically go into the timeline, and they'd be also available as highlighted text in the transcript or in the document as an annotation. And then here you see that the sort of information that goes in the facts at this level, you have the start and end date, who it relates to, a description of it, and other elements about the fact. Other fields that are available are showing if it's contested by the opposition, and then if it's material or not. And this is important as the issues for dispositive motion practice center around looking at issues that have not been contested by material facts. So you can sort and filter on these to make that determination once you've identified them. Once you get all these facts, how do you deal with them and find them? Well, there's a series of filters built in, and these are some of the fields that you identify in the facts. So you have the name of it on the upper left, if it's contested, if it's material, document it came from, case participant. Any of these you can filter, you can sort to slice and dice your timelines. Well, with that, we're to the end, and let me do a quick summary. Timelining is more important than ever. The data, the electronic stored information we have in cases is growing fast. The important facts get lost in a sea of this data, and attorneys are less involved in their early review and production than ever before. Good legal timelining software is available. It allows you to structure your facts by issue, case participant, materiality, etc. You can link your facts to the actual documents, the key evidence in your case, and timelining software should be online, available to your legal work groups and secure in encrypted fashion. Timelining can be very useful for a number of purposes. Helps you prepare and cross key witnesses, assist in case valuation and settlement negotiations. It helps in client meetings. It helps you prepare and respond to summary judgment and other dispositive motions. And it's a dynamic support for your case facts during trial. With that, we'll wrap this one up, and I'll turn things back over to Stu.
Thank you very much, Gene. Now today we use some visual demonstrations and some images, and those images, they are all from our eDiscovery application, Lexbe eDiscovery platform, and that includes the ability to self-upload and process up to 10 gigabytes of documents per day into our system. You can load PDF documents, TIFF documents directly into our system. Timelining and other case management features are also included, as well as early case analysis features, and the ability to create pivot tables, charts, graphs, etc. In addition to our eDiscovery platform, we also offer a wide range of eDiscovery services that take you through the different case stages. We have a culling service, email collection. We process native documents, can apply eDiscovery OCR, and near-dupe groupings as well. If there are any questions that come up, please feel free to contact us at any of the email addresses you see on screen. Thank you all very much for your time in attending today's webinar, and we will follow up with the URL to access a recording of today's presentation and the slide deck as well. Thanks again for your time, and have a great day.